24th of June. On the last occasion, I'm okay. Highly average. Okay.
So the concern on the petition recommends item number 4. And Lordship have called for the record. As I have received my record, record is incomplete. Lordship will fix it on 19th, my lord. Will bring the entire 19th of this complaint.
Mr. Yasbara, learned standing counsel for the BTC. With consent from the other side, as for listing the matter on 19th.
Lordship.
Let the name of the KK Mohanta may be shown in the cause list. Sometimes it is difficult to find out. KK Mohanta is there, senior advocate.
You go to the rest.
The Lordship's order will be enough.
And that's all right, but why the, is there any color now? Okay. Okay, next.
Yes.
May it please your lordship.
Yes.
So with the consent of the other side, I beg to mention items 11 and 12 of today's list, my lord. Subject to the convenience of this honorable court, if this matter may please be taken up after the holidays, a date may be fixed, my lord.
Your lordship, matter may be fixed on 19th, 17th or 19th. I am for the respondent, your lord.
Okay, as agreed by learned advocates of both the parties, let's list the matter on 19th of July.
June.
17th.
17th of June.
This,
June, your
I
lordship.
prayed for after the
After the
holidays.
vacation. Let it be after.
There's no urgency.
Your lordship.
Madam?
Before
There's no
my
urgency, my lord. It's
Ah,
a land
urgency.
matter, my lord. It'll be, I'm ready, my lord. I'm awaiting the certified copies of certain documents, my lord. That is the reason I'm seeking an adjournment. After the holidays, my lord, subject to the convenience, a date may be fixed, lordship.
15th of July then.
Beg your lordship.
15th of July. It is
Deeply
a
obliged, lordship.
Tuesday. Meeting day.
In before vacation.
Pardon?
Before
vacation.
vacation.
Not possible.
Obliged.
May it please your lordship. Lordship, item number 10 of court number 14, my lord. It's a hearing matter, but my lord, I am for the claimant, my lord, respondent number 1. It's an injury case. 50% has not yet received. My lord, may fix the date on any coming Thursday or my lord next Saturday, Tuesday, my lord.
Who is, you inform the other side.
My lord, as
You-
today, my lord, that list has been deferred, my lord. That's why I make a mention, my lord.
But you have to inform the other side.
My lord, if this is come
Yes,
for
so Mr.
hearing.
Sharma. Mr. Sharma,
Oh, yes, my lord, he is there. My lord.
this item number 10, there is a pair for adjournment of the court number 14.
Next,
Okay. As agreed by learned advocates of both the parties, let's list the matter on
my lord, coming Tuesday, my lord, next Tuesday, my lord.
next Tuesday.
Yes.
Okay, all right.
17th.
17th. Yes.
Lordship, I'm praying for listing of this MSc appeal, Lordship. This is
When?
2017, coming Tuesday
Oh, hearing.
for hearing, Lordship. 2017 method, Lordship. She is already.
On 24th,
24th,
24th June.
June, obliged.
May I please, Lord?
Yes.
My lord, similar period, my lord, on 24th June, my lord. Not
Okay.
24th, on 26th. No, we have already given many. On 26th, Thursday.
Yes.
My lord, I have some MSc appeal as well as IA, which was not listed from the last 2024 fight.
I for what purpose?
There is delay condon and some of MSc appeal. We should,
Okay.
yes.
What do you want?
So that may be given at 8th July after vacation.
8 July, 8 July is vacation.
Vacation. Then 19 June,
19th of June.
19.
All right.
Okay.
19.
May it please your
6
lordship.
meters.
I beg to mention one CRPIO. The matter may be listed in the admission column, Lordship,
When?
on Thursday.
Thursday, possible?
Thursday, we have few cases. On hearing column,
No, admission column,
on 18th,
18th June.
18 June.
Lordship, date
But
another.
please, your lordship, I pray to mention for listing of CRP 211/2024.
When?
Lordship, any date, lordship,
This week or next week?
this week.
This week.
This week, under which column? Under which column?
Oh, hearing or order?
For hearing,
Hearing, 24th June.
24.
Lordship,
Highly obliged.
this another CRPIO. The matter may be listed on the hearing column, Lordship.
When?
A date may be given in the next week.
After vacation, already.
Maybe
No,
given
vacation.
before the vacation. Any date may be given before
19th.
19th June. Right.
May please, Your Lordship. Your Lordship, I'm praying for listing of an IA civil. Your Lordship, yesterday in item number 1, Your Lordship directed us to file an IA for correction.
Yes.
Yes, so we have filed it today. Can it be listed tomorrow along with the CRPIO? Obligement.
May I please also, RSA matter, new matter, my lord. My lord, matter will be listed for tomorrow, my lord. Letter of possession was issued, my lord, execution court, my lord. Emergency, my lord, RSA, my lord.
May please, Your Lordship. Lordship, I beg to mention for listing of an IA, Lordship, in orders column. If
Why?
possible, this week, Lordship,
On 13th.
13th. Obliged.
I beg to mention item number 6, my lord. I received an instruction in the morning from Engaged Council for the petitioner that she is suffering from throat infection, so could not come today.
Mr. Your good name?
A. Chaudhary, may the matter come on
A.
Thursday.
Sundari appearing on behalf of Mr.
Miss I. Das, Engaged Council for the petitioner.
Miss Idas.
Yes.
Item number
Item number 6.
of this court.
Yes. Devdut Nath and another.
Item 6 of our court.
Our court. Yes.
May it be fixed on Thursday, my lord.
Coming Thursday.
Yes.
Mr. Sunsal, learned counsel appearing on behalf of Miss Idas, learned conducting counsel for the petitioner, SSL is the matter on
12th, Thursday,
Thursday. Okay.
12/6.
Yes.
Much.
May I please, Your Lordship?
Yes.
Lordship, I would beg to, with the concern of the other side, I would beg to mention item number 13.
13.
13 of today's list. Lordship, the item may be fixed after vacation.
You are for appellant.
Petitioner, yes.
Appellant.
Yes, Lord.
Mr. Your good name?
Lordship, W. Hawk on behalf of Mr. A. Sattar.
Mr. W. Hawk, learned counsel appearing on behalf of Mr. A. Sattar, learned conducting counsel for the appellant with consent from the other side. You inform the other side.
My lord, I am from the respondent. Kindly a date may be fixed.
With consent from the other side, as for listing the matter on
After vacation,
after vacation. Okay.
on 17th July.
Obliged, Lordship.
Items from daily list, promotion bail application, item 1.
My lord, this is a charge sheet at bail, my lord, and this is the second bail, in fact, the third bail application. My lord, will call for the scan copy at this stage, my lord.
Madam. What is this? The case is pending now.
Case is, my lord, no evidence is examined till date, my lord.
No evidence is examined.
No. Charge has also not been framed. Recently, charge sheet has been filed on 14/5/2025.
Heard Mr. Ambitious, learned counsel for the accused, and Mr. Kosik, learned additional PP for the state respondent. This application under section 483 of the BNSS 2023 is referred by accused Yahya Khan, who has been languishing in jail as in connection with NDPS case number 132 of 2025. Corresponding to Hatigao PS case number 255 of 2024. Under section 21B, 22C, 29 NDPS Act. Pending in the Court of Learned Additional Session Judge number 3 Kamrup M. Kamrup M since 13/11/2024. Having heard the submission of learned counsel for both the parties, it is provided that the SSL call for the scanned copy of the record from the record and the case diary from the learned trial court, fixing the matter on.
Can it be on 20th, my lord, 20th of June, because this is from Kamrup Metro itself, my lord. Check this.
Okay.
And before.
Item number 2.
May I please, Lordship? My lord, the third application, Lordship. Now,
What is the ground?
Lordship,
The
procedure of
ground of
arrest was,
arrest not communicated.
Lordship, not communicated, and long incarceration, that is also one of the
Long
grounds.
incarceration.
Yes, Lordship.
Here also scan copy.
Lordship, I have
Can
an,
be- Where it is pending?
in the court of additional session judge FTC, North Satnamara, Bongaigaon.
Bongaigaon.
Lordship.
Heard Mr. M.I. Hussain, learned counsel for the accused, and Mr. R.R. Kaushik, learned additional PP for the state respondent. This application under section 430. No, 483 of the BNSS 2023 is referred by the accused. Krishna Sil, who has been languishing in jail as in connection with Jogi police case number 94 of 2023 under section 302 IPC
Since 10/3/23.
since 93 or 23.
Yes, Lordship.
93 or 10-3.
Lordship. Forwarding report 10/3, phase 14.
But why you have mentioned it in the cause title as 93?
Lordship, 9/3, he was arrested, thereafter produced on 10/3.
Okay, 10-3-2023. 10-3-2023. Having heard the submission of learned counsel for both the parties, it is provided that justice shall call for the scanned copy of the record at the case ID from the court of learned
Additional session judge FTC,
court of
Bongaigaon.
learned additional session judge Lord Salmara Abhayapuri, Bongaigaon.
Yes, Lordship.
Session case number 27J 2023 arising out of Zugigopa PS case number corresponding to Zugigopa PS case number 93 of 20.
94, Lordship.
At what is this the case is pending now?
Evidence stage, Lordship.
Evidence.
Lordship.
How many witnesses have been
Out of
examined so
16,
far?
out of 16, 10 are examined, Lordship.
10 are examined.
Out of 16. In fact, Lordship, the ground of arrest memo notice under section 50 and inspection all are annexed, Lordship. Page 35, Lordship.
Listing the matter on not Palmora, COVID.
Next,
23rd June.
Lordship,
Item number
next week
3.
I need it, Lordship. Next week I need it.
Pardon?
Next week I need it kindly, Lordship. Next week I need it.
When?
I am playing for next week, Lordship. Listing on the next week, Lordship.
Okay.
19 June.
Obliged, Lordship.
Item number 3.
None appears for the accused on call is the matter after 1 week.
Item for admission, item number 5, parted matter. Sorry, not parted matter.
My lord, here matter lordship has heard in line in earlier, the matter relates to my lord, whether the NOC from the government is required for getting affiliation from the university for starting the my lord LLB, BL, LLB, and BLLB course, integrated course, my lord. As per the BCI rules and regulations, my lord. So earlier, lordship, my lord, I have already submitted the BCI rules, my lord, which specifically stated that in case of the private college, the NOC is not required, and the affiliation is always guided by the UGC, by the UGC rules. So UGC also filed the affidavit.
Okay, that's all right. Where is Mr. Fukon?
Listen, so
TJ Fukon, University. What university?
So I have some number, I'll type.
it is very
Let
God-sake
it come.
difficulties, my lord, because the other matters are there. Sometimes
And
it.
that's all right, but we hear both the parties.
Yes, my lord. Then, my lord, they. Okay, my lord.
Items 17 for orders.
Then, my lord, after some time, my lord.
After some time, whenever Mr. Fukon available.
My lord.
17.
In this case, Lordship, we have filed objection, but that is not on a record, Lordship. So it like,
This is for withdrawal of the amount, Lordship, 50%.
we have.
What is the amount?
Lordship,
What is the amount?
the amount of 26 lakhs 5,400 rupees. I am the claimant in this case.
We have filed objection to that, Lordship, but our objection is not found in the record, Lordship.
When did you file?
On 4th or 5th, Lordship, next week, last week, Lordship.
Section 427. After some time, he will compare it with the section.
Items for hearing. Item number 6, partner matter.
May it please your Lordship. In this matter, in fact, Mr. P.K. Bora will appear, Lordship. So from my side, there was a prayer to take up the matter at 2.
Take up to take the matter on
At 2, Lordship, today.
at 2.
But apparently petitioner is not. In that case, some other day.
6 has already been mentioned.
Mentioned?
Yes.
I'm sorry, Lordship.
Item number 7.
For the appellant.
Who are for the respondents?
Yes, my lord. I am for the appellant.
You are for the appellant.
Yes.
Whether the respondents are present in the court today.
My lord,
Counsel for the respondents are present. I alone.
do not know, my lord.
No.
Do not know. Maybe fixed on any other day, otherwise, my lord. A date may be fixed, my lord, on any other.
Date.
Yes, my lord.
When?
If they are not present, my lord.
When?
After 1 week, my lord.
After 1 night.
Yes, my lord.
Heard Mr. M.J. Kadir, learned counsel for the appellant. None appears for the respondent on call. List the matter after 1 week on 24. In the event of subsequent non-representation of the respondent, appropriate orders shall follow.
My lord, can it be on 26th, my lord?
26. All right.
Item number 8.
It's coming, Lord. He's coming.
Coming. So can we start?
Yes, ma'am.
Yes, start.
May it please the Lord. My Lord, the plaintiff, this appeal is against the judgment of reverse payment. Learned trial court was pleased to degree the suit of the plaintiff. The suit was for declaration of the right title on the land holding right, my Lord. In fact, they are the tenant of the suit land, my Lord. And it was decreed in their favor, and the lower appellate court reversed the judgment. The facts of the case is that the plaintiffs and their father, grandfather, they were the tenant in the land, my lord. The land was originally belonging to some landlord who in the year 1947, after the India-Pakistan partition, they went to Bangladesh and their land was exchanged by some people who came down from former East Pakistan to India, my lord. They occupied their land, but these people, the plaintiff, they were all along tenant, my lord. After, as because they are the tenant of the earlier landlord who went to Bangladesh, my lord, East Pakistan, erstwhile East Pakistan, now Bangladesh. And in exchange, some people from East Pakistan came down here and they got the land, my lord. But the tiller of the soil is there, my lord. Tenants remain there. So earlier also in the 1958, my lord, your lordship might have seen the substantial question. There was a suit there because the new landlord were trying to disturb them. So they filed a suit and the suit was decreed. And on this issue, my lord, they filed appeal, the landlord. The appeal was also dismissed. It all along remained in their favor. Then the second appeal was filed also. Their right was established. Then letters patent appeal was also there. And this was dismissed and allowed in their favor. So all along, their landholding right over the suit land remained. And when in this time, my lord, again, the legal heirs of the new landlords trying to disturb them, my lord, and also they are trying to sell out the land to some other persons who respondent number 4 here in the suit, my lord. They filed the suit, it was decreed. And on the lower appellate court, on the appeal, the lower appellate court reversed the judgment. So, my lord, may I read out the judgment of the trial court for your losses, clearing the background of the matter, my lord. Trial court judgment starts from
Page number 28.
28. May I read from page 29, my lord. The suit came, the suit of the case coming on the final hearing on 24/4/2008 on one in presence of A.R. Chaudhary, advocate for the plaintiffs, and Mr. Prakash, the advocate for the defendants, has been sued for consideration to this day. The court delivered the following judgment. This is a suit for declaration of the landholder's right of the plaintiff over the sued land and cancellation of settlement record of the defendant one, along with other relief. The story of the plaintiff's case in brief is that they became the owners of the sued land from their father, late Suraj Ali, who got the same by way of inheritance and also through purchase from the co-sharers, and they have been maintaining their right, title, interest, and possessions thereon since the time immemorial, generation after generation. Sheikh Suraj Ali had youth right, your lordship comes to matter. The Sheikh Suraj Ali had youth right over the sued land under Ashralata Pal and Nasib Ali, who had proprietary rights over the sued land. The dependent number one is Jamindar and a very strong and powerful man, and since long past he is trying to grab the sued land and inflicted the father of the plaintiffs in many criminal cases. They have recently, with a view to grab the suit land, the defendant number 1 got a case filed by his son on the defendant number 2 in the court of subdivisional executive magistrate Karimgঞ্জ by case number so and so against the plaintiff, where from the plaintiffs came to know after going through the settlement record that the principal defendant 1 created some false and fabricated documents in respect of the suit land in collisions with the settlement staff. That on the strength of the said illegal preparation of the settlement record, the defendant number 1 and 2 are trying to sell the suit land to defendant number 6, and the plaintiff, finding no other alternative, have filed this suit praying for the relief as per prayer made in the plain. On the other hand, defendant number 1, 2, and 6 contested the suit by filing the written statement jointly. Suit against number 3 and 12 proceeded ex parte, and against defendant number 10 and 11 proceeded without any written statement, as they were failed to submit their written statement within the stipulated time. It is to be mentioned that during the pendency of the suit, the name of the defendant number 4 and 5 are struck off from the record. The case of the contesting defendant is of denial. They entirely submitted that the suit has no cause of action, suit is not maintainable, suit is barred by law, limitation, suit is defect in parties, etc., etc. Contesting defendant further submitted that the defendant number 1 has got Moroshi right over the suit.
What is this Moroshi right?
Moroshi right, inheritance right.
Inheritance.
Inheritance. Right over the suit property, and he has acquired absolute right title over the said property by way of inheritance from his father, by way of gift from his mother, and by way of purchase from heirs of his brother, and enjoying the same by paying regular revenue to the government. Record of rights is also prepared in the name of defendant number 1. That the defendant number 1 executed registered Bainama on 2/9/97 in favor of the defendant number 6. Here is the peculiarity of the case, for in respect to the suit measuring an area of 2 kata 1/6 justi appertaining to survey diag number so and so and under Khatir number so and so, by the plaintiff whose malafide intention has filed the instance suit as well as without any basis. So the instance suit is liable to be dismissed with cost, page number 3 of this. On the above pleadings, my learned predecessors in chair framed the following issues for the suit: whether there is a cause of action for the suit, whether the suit is maintainable in the present form, whether the suit is bad for defective parties, whether the plaintiff is entitled to get degree as paid for, what other relief or reliefs the plaintiff is entitled to. On the above issues, plaintiff side examined 3 witnesses and the defendant side examined 5 witnesses. Both the sides have exhibited some documents. I have heard the oral argument of the learned counsel of both the sides, gone through the records and perused the evidence. Discussion and decision, issue number 1. This issue relates to the cause of action of the suit. The plaintiff filed a suit with allegation that on the basis of the wrong entry of the suit land in the settlement record, defendant number 1, 2, and 6 are trying to forcibly dispose the plaintiffs from the suit land, while on the other hand, defendant denied the same. From the pleadings of both the parties, it appears that the fact of the disposition and the title of the plaintiff which is at stake needs to be determined in the present suit. As I held that there is a cause of action for the suit. Issue number 2. This issue relates to the maintainability of the plaintiff's suits. Learned counsel for the defendant took the plea that the suit is not maintainable in view of the non-issuance of notice under section 82 of the CPC to the state of Assam and other officials. From the plain perusal of the case record, it reveals that the court had already allowed the plaintiff to institute the suit without serving statutory notice to the pro forma dependents 7 and 9. And these dependents were duly appeared in the suit. Furthermore, the plaint is accepted by the court. So in view of this, I hold that the suit is very much maintainable. This issue is decided in positive in favor of the plaintiff. Issue number 3, this issue relates to the defective parties. None of the parties, so it is gone, my lord. Issue number 4 is the vital. These issues relate to the degree as paid for in the suit by the plaintiff. Plaintiff filed the instant suit for declaration of landholder right over the suit land and cancellation of the name of defendant number 1 from the settlement record which had been wrongly entered by the settlement authority. While on the other side, defendant entirely denied that the suit land belongs to the plaintiff. In order to prove the contention of 51, Mr. Makhlusur Rahman reported that the suit land is under it should be their possession since generation after generation from the days of three grandfather Hussain al Muhammad, who was a Jute tenant under the landlord Aminul Haq Chaudhry as well as Nasib Ali in respect of the first and second scheduled land of the suit. On the death of Hussain Muhammad, his son Suraj Ali and late Afriz Ali inherited the suit scheduled land in Jute, right, and thereafter the present plaintiff are possessing the suit land. PW1, in order to draw the Jute right, show the Jute right, submitted Exhibit 2 and Exhibit 7, 9. I have gone through the exhibits. Exhibit 2 is the Farooq's land receipt issued by Ashalata Pal through her husband, Sri Nivaran Pal, in favor of Suraj Ali, father of the plaintiff, and Exhibit 7 is the land receipt issued so also in favor of Suraj Ali by Nasib Ali concerning connecting the suit land. Both these documents are 30 years old documents. I have also gone through Exhibit 1, deed of exchange number so-and-so dated 13/11/1951 between Aminul Haq Chaudhry on one part and Suraj Chandra Pal, Harish Chandra Pal and Ashalata Pal on the other part, by which Aminul Haq Chaudhry exchanged his property and left her erstwhile East Pakistan. Thereafter, said Suraj Chandra Pal, Harendra Chandra Pal and Ashalata Pal amicably partitioned their property, and Suraj Ali became the Jute tenant under Ashalata Pal, which is amply proved from Exhibit 2. So for the question of Jute tenant of the plaintiff is concerned, it has been amply proved from Exhibit 2 and 7. Since these documents are 30 years old documents. Now, the question arises whether the documents are in connection to the suit land. Defendant's contention is that the suit land does not relate to the aforesaid documents. They have submitted few documents wide Exhibit A to Q, showing that the suit land belongs to defendant number 1 by right of purchase from his predecessors. DW1 Jyotirmoy Das in his deposition stated that the suit land is under the possessions of defendant number 6, which has been sold to him by registered sale deed so-and-so, dated 18/10/2004. But DW2 Abdul Rauf Chaudhry, father of the defendant 6, when deposed, he just stated, contrary to the versions of DW1, as for him, in his examination in chief, he stated that the suit land is absolutely under the occupation of Sri Jyotirmoy Das, the defendant number 1. So from the contradictory statement, it can be well gathered that neither the defendant 1 nor the defendant number 6 are in possession of the suit land. Rather, the preponderance of the probability seems to lie in favor of the plaintiff, that the possession of the plaintiff of the suit land is intact since long. It has been already alleged with the plaintiff that the defendant number 1 name has been wrongly entered in the settlement record after they came to know from the filing of 145 CRPC proceeding before the Executive Magistrate Court by Defendant 1 and 2 in the year 1997, alleging encroachers. But from the facts and circumstances concluded, it appears that the defendant number 1 having no possessions of the sued land, and thus the entry in the Jamabandi is not made in actual factual description, and settlement authority had entirely ignored the possessions of the plaintiff and prevented their entry in Jamabandi. So, mere entry of the name of the defendant number 1 in the record could not pass any title in the absence of the establishment of relation to the sued property. Therefore, I held that due to long possessions in time immemorial, plaintiff's name ought to have been entered in the settlement record as landholder, and they are entitled for a degree as part made in the plain. Accordingly, the suit is decided in positive and in favor of the plaintiffs. So accordingly, the suit was degreed in favor thereof. So when the respondent and defendants filed the appeal, my lord, learned lower appellate court reversed the judgment, and it starts from page 42, my lord. The apparative parts may be taken from page 43. That the courts below failed to appreciate the evidence on record. That the court below ought to have dismissed the suit for the want of proper valuation. This of course is answer. Next parameter. The plaintiff's case in brief is that late Hassan Ali Hussein Ali, grandfather of the plaintiffs, was a jute tenant in respect of the suit land, Schedule 1 land under the landlord Aminul Chaudhry and others. On the death of his son, late Suraj Ali and Afroz Ali, the father of the pro forma dependents number 12, inherited the said land in jute right from the proportionate to their share by paying rent to the landlord. Said Jamindar exchanged the property then existed in India against the property of Suresh Chandra Pal, Harish Chandra Pal, and Srimati Ashalata Pal existing erstwhile East Pakistan by deed of exchange number so and so dated 13/7/57 of Karimganj Sub-Registry Office. Accordingly, in pursuance of the said deed, Suresh Chandra Pal and others became landlord in the proprietary right of the tenanted land, including the said first schedule on amicable partition amongst them in the first schedule land fell in the share of Ashalata Pal, under whom Suraj Ali was a jute tenant who occupied the same till acquisitions of the proprietary right by of government. One Nasib Ali of the village Kornamadu was the owner of the land described in the schedule 2 of the plain, under whom Hussain Ali was a jute tenant. After the death of his son, Suraj Ali and Afroz Ali became the tenant, and after their death, on amicable partitions, plaintiffs became the owner in the landholder right of the sale. In 1964, after acquisitions of the proprietary right under the State Acquisition of Jamindari Act 1951, late Suraj Ali acquired titles of landholder in the jute land under the state. Said Suraj Ali being tenant of some other land under Ashalata Pal, Harishchandra Pal, and had filed a number of cases against Suraj Ali in the court of Munshaf number 1, Karimganj, and the suit was contested up to Honorable High Court. And all such cases, the tenancy right of Suraj Ali was established. Defendant number 1 being Jamindar of the village, Kornamadu, was very close to the said Harendra Chandra Pal. On failure of the Horrendous Chandapal, the cases brought against Surujali, he being the instigated by Horrendous Chandapal had filed the miscase number 3167 in the Court of Executive Magistrate Koranganj under section 144 CRPC in respect of the land mentioned in the schedule of the plain against Surujali and his brother. Says suit was decreed in favor of Surujali. The plaintiff have their homestead on the portion of the first schedule land. The share of performer dependent number 12 has been sold to Abdul Roof, and former defendant number 10 also sold his share, and former defendant 11 got separated share. As such, the plaintiffs are possessing the 4.5 acres of land origin of the original tenanted land of Hussain Ali, measuring 5 into 3/3 katas. During the last settlement survey, settlement staff found the plaintiffs in possessions of the said recorded their shares in the field book. Subsequently, when plaintiff served the record of miscase number so-and-so under section 144 CRPC filed against them by defendants number 2, came to the knowledge the defendant number 1 created false deeds in respect of the scheduled land in coalition with the settlement staff. Moreover, the defendants are also trying to sell the land to defendant number 6. The defendant number 1 or other defendants without having right title possessions are trying to grab the land of the plaintiff, hence the suit. Defendant 1, 2, and 6 jointly filed a written statement raising usual legal pleas. They denied all the materials environment in the plaint. It is pleaded that the suit land had not been properly described in the schedule of the plaint. Their plea is that the land described in the schedule of the written statement is the khas land of the predecessors of the defendant number 1, late Yogendra Chandra Das of Konnamodu, who had purchased the land covering dag number 457, 458 under Qatiyar number 452, 447, new dag 1, 455 and 607, white patta number 167, Moja Konnabandhu part 4 from different owners, white purchase deed dated 17/1/1308 BC, executed by Ashraf Ali, and land pertaining to dag number 1 of Kavla registered purchase deed dated 12/12/1314 BC, executed by Asan Ali, and land pertaining to dag number 1 of Kavla registered deed 1/1/1320 as executed by Kuntra Chandra Das and Radha Raman Das, and land pertaining to dag number 1 of Kavla registered deed dated 25/5/2013-20 as BC, executed by Abhay Charan Das, and land pertaining to dag number 1 of Kavla registered deed dated 5/9/2013-20 as executed by Harichandran Das and Sarantandra Das, and land relating to dag number 1 of Kavla, land covered by dag number 788 being purchased by predecessors of dependent number 1, late Yogendra Chandra Das, purchased the landed property along with other property through court auction. Certified copy of the land issued by subjudge numbers of Sylhet, Bangladesh, dated 12/2/1912-40, and said land covering dag number 788 is under Qatiyar number 447, new patta number 157, white dag number 617, land covered by number 455, 456 under Khatiyar number 447 were purchased by Jogendra Charan Das from different owners through various deeds as mentioned below. So, my lord, in the last part, these are the different tax number mentioned by. Accordingly, last paragraph, accordingly, petitioners of the defendant number 1 having purchased the lands through various cabals acquired right title and propositions of the recorded his land. After acquisition of Jamindaris by the government in the preparatory right be invested through the governance in respect of the landed property described in the schedule along with other lands. However, land of written statement being khas of dependent number 1, he has declared as the landholder by state of Assam in respect of the landed property described in the schedule of the written statement along with other land. After death of Jogendra Charan Das, 3 sons, namely Jagadish Chandra, Jagadish Das, Jugesh Das, and defendant number 1 inherited the same along with their mother Sushilata Das. Subsequently, Sushilata Das gifted her share in favor of defendant number 1 by gift deed number so and so dated 29/3/75. That before execution of the said gift deed, Jagadish Das sold his share in favor of the defendant number 1 in respect of landed property by registered deed dated 6/3, then 7, something well it is missing. In heirs of the Jagadish Das, namely Sushilata Das, Janakinath Das, Jugendra Das, Javitish Das, had sold their share in respect of the landed property described the schedule of the written statement to defendant number 1 by registered sale deed so and so dated 13/3/74. As such, different number became the absolute owner in respect of the landed prescribed in the schedule along with other land by inheritance, purchase, and gift above. It is stated that the plaintiffs filed the suit with false averment and false faruqs. The defendant number 1, due to urgent need of money, entered into a contract for sale of 2 cutters 1/6 justi land from Dag number 557 under Kasiyan number so and so, Moja number so and so to defendant number 6 on 2/9/97 at rupees 70,000 per kata, and as such, on receipt of 50,000 from defendant number 6, executed the registered Bainama dated 2/9/97 with a condition that within 30/4/1998, he will execute the proper sale deed after receipt of the balance amount. Plaintiff with bona fide intent and malafide intention and causing loss to defendant number 6 have filed the suit with a false averment in view of the same. They prayed for the dismissal of the suit with compensation of rupees 3,000. Record reveals that the suit against defendant number 3/12 proceeded the ex parte and defendant number 10 and 11 could not file written statement. Names of the defendant number 4 and 5 were struck off by order dated 21/12/2000 upon pleadings of the parties. The appellate court framed the following issues, my lord. That is the issues that were formed earlier. During the pendency of the appeal, respondent number 1 died and his legal heirs were substituted as per the order so and so. Plaintiff side examined 3 witnesses, whereas defendant side examined 5 witnesses. Both sides also exhibited certain documents. Learned court below, after hearing the argument from both sides and having gone through the record past the impugned judgment, I have heard said Sri A.K. Das, Learned Counsel for the appellant and Sri A. Rashid, Learned Counsel for the respondent, also carefully gone through the pleadings of the parties, evidence and record, and the impugned judgment. My discussion and decisions on the issues as follows. On scrutiny of the plaintiff, it appears the plaintiff have filed a suit challenging the Khatian number so-and-so or Moja Karnavodu part two is standing in the name of defendant number 1 to 5 in
Mr. Mazarvia, you come to discuss on issue number 4 because that is the vital issue.
yes.
You know, this issue was also discussed in issue number 2 in detail.
Both are discussed together.
Yes, no, not together, but then this fact melody is this issue virtually, therefore, my lord, this may be
Required.
required.
Okay.
Issue number 4 and 5, my lord, at page 53. These two issues being related to relief of the plaintiffs discussed together. For the elaborate discussion held in issue number 1, which is most vital issue in the suit, it appears that the plaintiff side has failed to establish the right title, interest, and possessions of the suit land, and as such, they are not entitled to get the relief in the suit. The issues are answered accordingly.
Issue number 2 is.
Okay.
Issue number 2. Page 47.
45. On scrutiny of the plaintiff, it appears that the plaintiff have filed a suit challenging the Kachan number 452, 457, so the Moja Karnavodu Part 4, standing in the name of defendant number 1 to 5 in respect of the suit land. They have sought the declaration of the said Katians and on the for Katians as fraudulent and illegal nots, but surprisingly, settlement officer and the state of Assam have been implemented as pro forma defendants. Although the plaintiffs challenged the actions of the revenue authorities as illegal by preparing and issuing the Katians in the name of defendant number 1 to 5, again, plaintiff side has not sought for any leave under section 80, subsection 2 of the CPC, serve notice under section 80 CPC before institution of the suit against the settlement officer, Karimganj, sub-registry in Karimganj, in the state of Assam. Therefore, on this count, the suit is not maintainable on the facts and circumstances. It appears that in the impugned judgment, Learned Trial Court did not consider this aspect of section 80 of CPC and relief sought for in the instant case, and consequently failed to decide the issue in true perspective. Issue is decided accordingly in negative and against this. So this issue is against the plaintiff defendants, my lord, because of their failure to serve notice on the statement and getting in response from the state authorities.
Issue number 1.
আর কত এনার বাড়িতে one.
Issue number 1 take.
Yeah, আপনি শেষ করে দিলে হয়। This is my lord, issue number 1, my lord. This is the most vital issue where the crux of the dispute laws. As for the contentions, the plaintiff dependent number 1 or other dependent without having right title and possessions over the suit land created certain false documents. Further, the contents of the plaintiff is that final Khatyan in respect of the suit land was illegally recorded and issued in the name of defendant number 1 to 6. Defendants, on the other hand, have totally denied right title and possession of the plaintiff of the sued land and pleaded that the Khatian was rightly published in the name of predecessors of defendants. In view of the contention raised by the defendants, pleadings in the order to prove the cause of action as to prove that they have right title and possession of the sued land, the filing Khatian of the sued land was wrongly prepared and issued in the name of defendant number 1 to 6. Admittedly, the Khatian stands in the name of defendant number 1 to 6. Sued land has been described in the Schedule 1 and 2 of the plaint. As for description in the plaint, the Schedule 1 pertains to dog number so and so Khatian number 447 and dog number 457 of Khatian number 452 of Mauja Karnavoda Part 4, the first scheduled land, is appertaining to Dalak number so and so. The second scheduled land is described in the plain appertained to Khatian number so and so, Murad Muhammad, and land is covered by Dag number 457 of the Mauja Karnavoda. The plaintiff side during trial exhibited say 2 Khatians. Exhibit 10 is certified copy of the final Khatian number 447. The same is Miraj Khatian standing in the name of Jagadish Chandra Jyotirmoy and Suman. Therefore, it appears that the description of taluk of the first schedule land in the plain regarding the taluk does not tally with the taluk of Exhibit 10. Exhibit 11 being final Khatian 457 covering Dag number 457, whose part relates to the scheduled land, stands recorded in the name of Jatish Chandra Das, Jyotirmoy Das, and 5 others. Exhibit 11 is the Miraj Khatian. Exhibit 10 and 11 were prepared, recorded, and published as per provisions of the Sylhet Tenancy Act. So, my lord, in fix, these documents, according to the plaintiff's allegations, were prepared by the defense with fraudulently by maneuvering with the making manipulations with the government officials. But the fact lies with them, my lord. Plaintiff side, they did not, as stated in the judgment, did not make the state respondents strongly and did not bring them before the court, rather avoided. Had it been so, then it could have been proved in their favor, my lord. So it is lying with them. So, though they have a good case, my lord, but they could not fulfill it as it appears from the judgment. But leave it before your losses, my lord.
Yes, Mr. Roy.
My lord, I'll read issue number 1, my lord. Issue number 1, because this is the issue where entire case of the plaintiff, my lord, he could not prove his case was discussed. I'll read it, my lord. Move on. My lord, this is the most, may I read it? Your lordship will kindly look at page 48. This is the most vital issue where the crux of the dispute lies. As per the contention of the plaintiff 1 or other defendants, without having right, title, and interest in possession of the sued land, created certain false documents. Further, the contention of the plaintiff is that final Khatian in respect to the sued land was illegally recorded and issued in the name of defendant number 1 to 6. Defendants, on the other hand, have totally denied the right, title, in possession of the plaintiff over the sued land and pleaded that the final Khatian was rightly published in the name of the predecessor of the defendants. in view of this contention raised by the defendants, plaintiffs, in order to prove the cause of action, has to prove that they have a right, title, and possession of the suit land, and final khatiyan of the suit land was wrongly prepared and issued in the name of the defendant number 1 to 6. Admittedly, khatiyan stands in the name of the defendants number 1 to 6. Suit land has been described in the schedule 1 and 2 of the plain. This part of relevant, my lord. As per description of the plain, first schedule land appertains to dock number 455, 456, 458, 452, 788 of khatiyan number 447 and dock number 457 of khatiyan number 492 of Moza Karnamadhu part 4. And first schedule land is appertains to taluk number 1475768 Ghulam Nasir. Second schedule land as described in the plain appertains to taluk number 1477/83 Murad Muhammad and land is covered by dag number 457 or Moja Karnamadhu. Plaintiff side during the trial exhibited Exhibit 10. My lord, this is their exhibit. Exhibit 10 is certified copy of khatiyan number 447. Same is Miraj khatiyan, standing in the name of Jyotish Das, Jyotirmoy Das, Jonaki Das, and others. Land in Exhibit 10 is recorded appertaining to Mohol Taluk 1476778, Ajmat Ali. Therefore, it appears that description of the Taluk and first schedule land of the plain regarding Taluk number does not tally with Taluk of Exhibit 10 and 11. This is their exhibited documents. The plain's description does not tally the documents they exhibit. Being final khatiyan, the Exhibit 10, 11 being the final khatiyan of 457, covering the number 457, which relates to the second schedule land, stands recorded in the name of Jyotish Chandra Das. Jyotirmoy Das, the defendant. Exhibit 11 is Miraj khatiyan. Exhibit 10 and 11 were prepared, recorded, and published as per the provision of Select Tenancy Act 1936. Final khatiyan is a prima facie document of title and possession of the concerned persons, in whose name the same is recorded. And final khatiyan is presumed to be genuinely and correctly prepared and published unless rebutted by stronger evidence. So they could not produce any evidence. Plaintiff side, in order to show that tenancy of Suroj Ali, who was the predecessor of the plaintiffs in respect to the suit land, exhibited two faroks. Exhibit faroks is the rand receipt of the jamindars. Faroks are rand receipts of the jamindars. Or Mirajdar. Exhibit 2 and 7. Exhibit 2 and 7 are not public documents. These are not public documents. On scrutiny of Exhibit 2 and 7, it appears that Tozi is not mentioned therein. There is no Tozi now. These faroks undoubtedly are not public documents, and as such, in order to be admitted in evidence, must be proved as per law. The trial court has, my lord, because 30-year-olds, it can't be, my lord, has to be proved. Even 30-year-old document, my lord, only the signatures are presumed to be the right person, of right person. The contents are not. There are decisions, sample decisions. Exhibit 2 and 7 have not been proved by the plaintiff, and Exhibit 2 and 7 have not been proved by the plaintiffs, and as such cannot be admitted in evidence. It appears that the impugned judgment and order trial court wrongly held Exhibit 2-7 being 30 years old and are self-proved documents. Lanet Munsif has failed to comprehend the spirit of Section 90 of the Evidence Act. Exhibit 2 and 7 not being public documents nor registered cannot be admitted to be self-exhibited documents under umbrella of Section 90 of the Evidence Act. PW1 number 3 so has deposed that Animul Haq Chaudhary and others, who was the Mirajdar of the suit land, exchanged the property with Suresh Chandrapal, Horendra Chandrapal, Ashalata Pal, wide registered deed number so. Plaintiff side has exhibited certified copies of the said documents of Exhibit 1. These are the deed of exchange. Side that amicable partition of Ashalata got the first scheduled land, and rather Suroj Ali became the Jodh Road under Ashalata. Thus, it appears that according to the plaintiff, suit land was tenanted land under Mirajdar, but Exhibit 10 speaks that first scheduled land was khas land of Mirajdar, whose names are recorded as Dakholdar. In cross-examination, PW1 is replied that he cannot say whether his grandfathers exhibited any kabuliyat related to the suit land. Plaintiff side has failed to submit any kabuliyat to show that the grandfather of his father was the tenant in respect of the suit land from the said Miratan. Plaintiff side has also failed to submit any document as regard the Toji account to show that their predecessor were the tenant in respect of the suit land. On the other hand, PW1 in his cross-examination has admitted that the defendant number 1 and ex-landlord was ex-landlord. Now the question arises whether Exhibit 1 covers the suit land. It appears that Exhibit 1 covered the suit land. PW1 in his cross-examination has stated that their homestead land is situated about 50 miles west to the suit land, but final khatiyan of their homestead land is not issued in their name. Had Exhibit 1 related to the suit land and the predecessor of the plaintiff as pleaded in the plaint were the possession, then their names would have been recorded in the tenant as final khatiyan. But Exhibit 10 and 11 prima facie show that the land is Mirage land, which were under their direct possession without any tenancy. That being the position, I come to the conclusion that plaintiff side has failed to establish their predecessor were the tenant in respect to the suit land. Exhibit 1 covers the suit land. Exhibit 3 and 4 do not show that the names were related to the present suit land. Moreover, these documents are not binding upon the defendants because declarative suit operating personam and not in rem. It appears that the defendant number 1, a predecessor of the defendants, were not a party to the suit. Now, not substantial question of claim. This is the only substantial question which was faced, my lord, in respect of that suit. My lord, substantial question number 1. Whether the learned appellate court below committed an error in law in not considering the judgment title appeal number so and so. This aspect was dealt with here because these present defendants were not a party. This was a declaratory suit. And there are decisions I'll place before lordship. Below, it's only between the decree holder vis-a-vis the judgment debtor, not others. This is a declaratory suit. So this can't be because unless and until they are made party, or their predecessor, and it is not their case that we have inherited from that judgment debtor of that suit. It is not their case. Therefore, that judgment cannot bind the present defendant. That was held in this case, and there are decisions also. So, my lord, there are no other, my lord, substantial question. And this being the questions of fact dealt with by the first appellate court, whether your lordship would like to, my lord, interfere in the second appellate. This is not a question of substantial question of law, my lord. This is only a question of fact. And this itself, my lord, is a question of fact. It is not a question of law. Because the appellate court has dealt with, clearly said the defendants being not a party to that suit, they cannot be bound by that. I can place before lordship the I'll place before lordship, we will go through it. First is, my lord, I'll only read the relevant paragraph, my lord, of the judgment, paragraph 10 of this, the 1974. About the lordship has got, my lord,
Yes.
2 SSC.
Whether this judgment in title appeal number 57 of 1958 is exhibited before the learned trial court?
And no, it was also not pleaded in so many words. There is no, in the plaint, it was not pleaded about this, only said there is some suit. It was not pleading in the pleading even. In the plaint, lordship will find in the pleading. It was not in so many words pleaded that there was a suit, this being the suit number so and so, they get a decree. There is no such pleading as such. Specifically. So unless there is a pleading, how can they, my lord, adduce evidence to that? That is the thing.
No, in which part first appellate court has dealt with that suit?
No, this is not in relation to this suit. That is a different issue. My lord,
No,
first
that's all
appellate
right.
court, my lord, yes.
Since substance.
Yes, my lord, this part is here. Towards the end, I read just before lordship.
Yes.
My lord, page 50. My lord, that being the position, I come to the conclusion the plaintiff side has failed to establish that their predecessor interest at Terence and so. Exhibit 3 and 4 do not show that same related to the present suit, 3 and 4. Present suit. Moreover, these documents are not binding upon the defendants because declarative suit operating personam and not in rem. Lordship got it, my lord. Not in rem. It appears that defendant number 1 or predecessor of the defendants who were not party to the said relevant suit. So unless they're party, there is no question of looking into it, my lord. They must be party to they must know.
No, this judgment was exhibited before the trial court?
3 and 4, that was 3 and 4.
3 and 4.
Yes.
Okay.
That's that judgment, the appellate court. Trial court did not deal with this, you know. Trial court only decreed the suit on the basis of Farrock's, the rand receipts, being 30 years old, and nothing else.
Okay.
My lord, may I read this judgment, my lord, and only relevant paragraph?
Please, 1 minute.
Lordship.
So exhibit 4 is the photocopy of the judgment and order in title appeal number 57 of 1950.
That's right.
Right?
Photocopy of the judgment.
Right?
Right. That was dealt with by the first appellate court.
Okay.
Not by the trial court.
Yes.
Now, my lord, lordship got 74(2) SCC. Lordship will come to paragraph, my lord, 10. It is a subtle position, but then I think lordship, I can raise the law. It is a set, my lord got it. Paragraph 10, page 371. It is settled law that High Court in second appeal cannot appreciate the evidence and interfere findings of fact reached by the lower appellate court. The lower appellate court is the final so far as the findings fact are concerned. The only limited ground on which the High Court can interfere in the second appeal is that the decision of the lower appellate court is contrary to law. It is only an apparent error of law which can be corrected by the High Court in exercise of its jurisdiction in second appeal. If the findings according to the lower appellate court is one of law or mixed question of law or fact, the High Court can certainly examine the correctness. But if it is purely question of fact, the jurisdiction of the High Court would be barred and it would be beyond the ken of the High Court unless it can be shown that there are error of law in arriving at the said finding based on no evidence or was contrary to law and unreasoned arbitrary. This is the settled position of law. Now, my lord, this fact, this is a question of fact. My lord, all these are question of fact decided by the first appellate court finally. Now, your lordship cannot look into every aspect of the trial court's finding, my lord. Unless they say that, yes, I was a party in that suit, and the decree was also against me, that would have been a question of law, my lord. This is a question of fact.
No, court can look into the facts if the appellants take the plea of perversity.
No, that's right. Where is the question? Where is the plea of perversity? Where is the question of law here in perversity? There is none. And there is no substantial question of law on that also. Right, your lordship is right. Perversity is a good ground in second appeal. It's a substantial question of law. Here, the appellate court has discussed every piece of evidence and found the exhibit 10 and 11, which they have exhibited, does not tally with the description of land given in the plain. This is a question of fact. Now, my lord, next is about the presumption, section 90. Lassi Borua, lordship got it, my lord. 1996, paragraph 16. Para 16, my lord. It says, so far as the applicability of presumption arising section 90 Evidence Act in respect to the copy of the old document is concerned, the earliest decision of this court was 1880, so-and-so, Mukherjee, so-and-so. Later on, the decision of various high courts, the presumption of section 90 was also made applicable to the certificate copy. The Privy Council now review the authorities, however, did not accept this so-and-so. And the decision of the high court, when the presumption was attached also to copies as correct, it has indicated that in view of the clear language of section 90, the production of the particular document would be necessary for applying the statutory presumption of section 90. If the document produced was a copy admitted under section 65 as secondary evidence, this is secondary evidence, and it was produced from proper custody and was over 30 years, then the signature authenticating the copy might be presumed to be genuine. But the production of the copy is not sufficient to justify the presumption of due execution of the original document under section 90, so and so. So, my lord, what they exhibited is the land receipt given by Javindars and a counterpart of land receipt, not even the original, counterpart of the land received given by, this is not a public document, my lord, by a private person. And signature of that Javindar or the Javindar would have come, or the successor should have come to approve that document. This is admittedly section 65 document, my lord. Next one is also on the same line, my lord, paragraph 18. This 1954 one, this is the old one. My lord, it is in the same line. Lordship will, paragraph 18, Lordship will, in the same line. And I've given 2005 9 SCC also. It is the latest one, 2009, my lord. 2005 9 SCC, page 359. Gangamma and others. Here also this says the section, this also deals with section 90. Paragraph 8, my lord, 7 and 8. Even if executed, my lord, this doesn't prove the document itself. And my lord, this 2003 3 SCC 472, this raised to, my lord, para 13. Here, my lord, they have challenged the revenue record. The settlement officer is not made party, the state of Assam is not made party. So, para 13, my lord, will kindly see. The question that needs to be addressed is whether Chief Conservator of Forest as appellant petitioner in the writ petition appeal is mere a description of the state Andhra Pradesh, whether it is a case of non-generous transfer, a necessary party in a lease dealing with the property of the state, there can be no dispute that the state is necessary party and should be implemented under Article 30 and Section and 79 of the Evidence Act. My lord, the state of Assam ought to have been made a party because they have challenged the action of the state. They have challenged the lease, the cause of action arises when the revenue record is written in my name. That is not, that in that context, my lord. And here also the settlement officer has been made pro forma defendant. State action is challenged, settlement officer cannot be made pro forma, it must be main defendant because his action is put to challenge. And this is section, next is section 80, but I will not much rely on this because the trial court has a finding, I find, that the court has given the section 82 liberty has been given. There is some order passed by the trial court. That there is a finding of the trial court, I found. Therefore, my lord, section 80 notice, I am not much pressing, my lord, on this. This is because of the specific finding of the trial court I found that just now. So, my lord, the question of law, my lord, framed is not a substantial question no, in respect to the facts and circumstances of the case. And the first appellate court having gone into details of the finding and arrived at a finding of fact, my lord, lordship would not definitely like to, my lord, interfere in the second appeal. In view of the limited jurisdiction lordship has just for going into the questions of law, and that too in a substantial question of law.
Yes, Mr.
My lord,
Gormia,
the plaintiff, my lord, before while examining himself and two other witnesses, my lord, and he cited exhibits were proved before the court, my lord. By the plaintiff examined himself, and he also adduced the evidence that is the earlier judgments, and also Farouk's and these things were examined by, were produced before the court, my lord, in presence of the defendant sides. So apparently he examination is PW1 Makhlisur Rahman.
No, that's all right. In respect of this first substantial question of law,
The document, the exhibits were proved before the court, my lord, by way of examining himself.
so it is stated that appellate court below committed an error of law in not considering the judgment passed in title appeal number 57 of 19.
These judgments were proved before the trial court, my lord, by examining the PWs.
No, that's all right. Whether the present respondents were party in that suit.
Now, present respondents, these are the old suits, my lord. By that time, the present respondents' predecessors were the landlord by that time, and who were the tenants of that predecessor. That is, present
CRPC.
Number 9.
May I please your lordship? In this case, lower court record has been received. It is a very voluminous matter. So we need some document from there, photostat copy of the document. So only on the direction or holding IO will point out so that we can get the paper book. So appropriate order may be passed to
Regarding?
paper book of this voluminous document because all the document is not required. There is a document pertaining to the Gohpur Thana state.
You obtained certified copy?
So there are voluminous documents are there.
Maybe this is not an appeal, it is a revision petition.
So then some time may be granted to take
So the
the.
question of preparing paper book does not arise.
Then we'll.
Yes, Mr. Bora?
Yes, lordship is correct, my lord. It's a revision application, my lord,
Revision
and they have
application.
filed a revision
Yes, we
application
have.
challenging the order of the discharge. All the document they have already relied on during the trial court.
Yes.
They have supplied every document, and on the basis of their documents, charge sheet and the other thing has been filed. It is all their document. It must be with them. Otherwise, how they have filed the charge sheet, how the charges hearing took place. They have started the charge hearing. They have opened the case in the trial court. It is their case, my lord. I have no objection if she collects it from wherever. my lord.
To collect certain documents because some
Okay.
documents are relating to the Gohapur Thana also.
Okay. The learned counsel for the petitioner submits that some of the documents available in the record of the trial court is not available with her. And as such, she applies for granting her some time to obtain copies of those documents and applies for listing the matter after vacation then? After vacation. After vacation.
Hmm?
Immediately.
29.
30th.
After
22nd of July.
When? 22nd.
Don't worry.
Uh, it-
22nd. Public.
March after.
Number 10.
Idea, na?
May it please your lordship. My lord, this appeal is filed, my lord, against the judgment and order dated 26/8/2016 passed by the Railway Claims Tribunal, my lord. And my lord, this is a matter of, my lord, untoward incident, my lord, where, my lord, the claim of the, my lord, applicant in the, before the Railway Claims Tribunal that, my lord, he's a bona fide passenger, my lord, father of the, my lord, applicant. And my lord, he boarded the train at Guwahati station to Borpeta. And in between, my lord, and Rongya and Khograpar, my lord, he fell down from the train and died. Now, my lord, our contention is that, my lord, it's a case of run over, my lord, not falling down from the train, my lord. Lordship, I'll, my lord, bring your lordship to the judgment, my lord. Annexure 1, my lord. Probably, my lord, it is page starts from page 9 onwards, my lord. This is the judgment, my lord. Then
So this claim tribunal has awarded a sum of rupees 4 lakhs.
Yes, ma'am.
Being the compensation. Then what is the ground for preparing the certain?
my lord, lordship may kindly come to para 15 of the judgment, my lord.
Paragraph 15.
Para 15, my lord.
Yes.
My lord, the accident has occurred during daytime near railway level crossing gate. There must be a lot of people standing both sides of the said railway gate, LC gate, and somebody must have seen the disease run over by any of the train passed through that track, but respondent has not produced any eyewitness, my lord. My lord, in fact, there is no eyewitness, my lord, to prove the fact. And there is every likelihood of the disease being run over after falling. My lord, this line is very important, my lord. there is every likelihood of disease being run over after falling down from the same train. My lord, now, my lord, it's a case of run over, my lord, which is proved from the, my lord, postmortem report as well as, my lord, the final report, my lord. I'll bring your lordship to the final report as well as the
No, that's
postmortem
all right.
report. where
He's
that
run over by the train.
run over.
Okay.
Now, my lord, in this regard, my lord, I'll produce two judgments, one by the Honorable Supreme Court.
No, first you tell me whether the standard of proof
My lord,
is beyond reasonable doubt or preponderance of probability.
my lord,
This is not a criminal case.
no, my lord. Yes, my lord. But my lord, thing is this, my lord. The Honorable Supreme Court has held, my lord, that when a person fell down from the train, my lord, he cannot go under the train, my lord.
No. That cannot be. That cannot be. I
cannot.
don't think that Supreme Court has observed in that line.
Exactly that way, my lord.
Ah.
And my lord, this Honorable Court, my lord, also observed that way, my lord. I'll produce two judgments, my lord. This is two judgments, my lord. My lord, first judgment, my lord, para 28, lordship, may kindly say. My lord, lordship may kindly come to para 26, my lord, first, my lord. My lord, burden of proof when body found on the railway premises, definition of passenger, my lord. My lord, the Honorable Supreme Court has relied upon some judgment, my lord. And one of the judgment, my lord, which is referred in para 28, my lord, Kamrun Nisa, my lord. From the circumstances appearing in that case, it was held that there is no evidence that the disease has persisted. The given fact situation of this case, this court interfered that it was not a case of untoward incident, but a case of run over. My lord, if it is untoward incident, it cannot be run over, my lord. The aforesaid report also revealed that the body of the deceased had been cut into two pieces and was lying next to the railway track. The report further indicates that the intestine of the disease has come out of the body. The above factual position revealed that the body was cut into two pieces from the stomach. This can infer from the fact expressed in the inquest report that intestine of the disease has come out of the body. It is not possible for us to accept that such accident could have taken place while boarding the train. My lord, this is relied, my lord, in my lord, this judgment passed by this Honorable High Court, my lord. The next judgment, my lord, para 21, my lord. My lord, there is one more aspect, my lord. I will go to that also, my lord. This is the, my lord, main fact, my lord, at para 21, my lord. My lord, para 21. From the inquest report dated 29/12/2014, it is seen that the body of the victim was found lying between the railway lines, facing earth, and brain matters and pieces of the skull were found lying scattered in the railway track. If the victim has actually fallen down from the train, as claimed by the appellant, it is clear that as to how the body could have been found lying inside the two railway lines. Now, my lord, if a person fell down from the train, my lord, he cannot go under the train, my lord. It will go outside, my lord.
No, this is not absolute rule.
Yes, my lord. But my lord, this is one point, my lord. My lord, I am harping on this point, my lord, number one, my lord. And the second point, my lord, the fact that, my lord, when, my lord, the information is given, my lord, that point, my lord, the train, my lord, the alleged train, my lord, from which he has fallen down, my lord, it has, my lord, already, my lord, at that point of time, it has already crossed that point, my lord. Lordship will come to the, my lord, DRM report, my lord, which is, my lord, as per the railway, my lord, railway act, my lord, a report is required to be produced, my lord. And my lord, to that effect, my lord, we have produced these documents also, my lord. we have produced certain documents, Report of the Divisional Security Commissioner dated 19/8/2013, R1. I'll read out that.
Part of this appeal?
Yes, not part of the LCR,
Yes, page number?
My lord, page number, my lord, LCR, page 2, my lord. My lord, my lord, in LCR, I do not know the page number exactly. My lord, it is, my lord, R1, my lord.
R1?
Yes, my lord. R1, page 2 of the R1, my lord. It's a DRM report, my lord. Also has got my.
You see, the judgment you have relied upon of this court.
Yes, ma'am.
In that case, the body was found between the two railway lines.
Exactly, my lord.
Here, it was found besides the line, railway
Besides the
line.
line, my lord, it was, my lord, if your lordship go to the report, my lord, hands were capped off, my lord. And my lord, just over the ballast, my lord, which my lord used, my lord, for laying the lines, my lord, ballast, my lord, Hilguti. It is written as Hilguti, my lord. So, my lord, this is the line. Ballast are there, my lord. So, over that, my lord. And my lord, hands were chopped off, my lord, cut off, my lord. If your lordship will come, my lord. And my lord, the postmortem report also says, my lord, it's a case of run over, my lord. So, my lord, run over means, my lord, the train goes over the body. My lord, I'll my lord, go to the postmortem report also, my lord. Now, my lord, second thing, my lord, the incident was informed, my lord.
His left hand was cut.
Yes, my lord. My lord, this, my lord, vocal cord came out. Lordship will find, my lord.
Not vocal cord, it is foot pipe.
Foot pipe. And my lord,
So this judgment of this court will not help you.
So, my lord, it was, my lord, the hands were kept, my lord, means, my lord, that the train has gone over this, my lord, over the body, my lord, person, my lord.
So in the case of the Supreme Court case you have referred to is also not similar to the facts of this case.
My lord, my.
There the body is cut into two pieces.
Yes, my lord. Here, my lord, hands were cut, my lord.
Only one hand was cut.
Yes, my lord. So, my lord, it was cut, my lord. My lord, body may not cut, my lord, but this, my lord, some, my lord, foot pipe came out, my lord. And my lord, they have, I'll read out, my lord. The rail liner, my lord, the Surat Hal, my lord, inquest report. My lord, Surat Hal, my lord, may I read, my lord? মৃতক এজন অচিনাক্ত পুৰুষ মানুহ মৃতক ৰেল লাইনৰ কাষৰ শিলৰ ওপৰত পৰি আছে অভাৰ দি ব্লাষ্ট বালাষ্ট মোৰ পৰি থকা দেখা গ'ল মূৰত সম্পূৰ্ণ জখম বাওঁ হাতখন চিঙা অৱস্থাত দেখা গ'ল ভৰি দুইখন আঁঠুৰ তলত থেতেলা অৱস্থাত দেখা গ'ল পেটৰ নাড়ীবোৰ ওলোৱা দেখা গ'ল পেটৰ নাড়ীবোৰ ওলোৱা বুলি কৈছে So, my lord, number one, my lord. And lordship, if your lordship come to the post-mortem report, my lord. Post-mortem report, my lord. Opinion, my lord. Opinion of the assistant surgeon as to the cause of death, my lord. My lord, the last line is legible, my lord. I can read out that line, my lord. The last line.
Okay.
The railway run over incident, my lord. It's a run over incident.
That is mere assumption.
My lord.
Mere assumption.
My lord, run.
But this inquest report may be more important.
Yes, my lord. So, my lord, my humble submission it was, he has gone, my lord, under the wheel, my lord. It's my submission, my lord. Lordship may disagree, my lord, but my humble submission, he has gone under the wheel, my lord, of the rail, my lord. So, my lord, if a person, my lord, fall down from the train, my lord, he cannot go inside, my lord, under the train, my lord. That is number one. And, my lord, the incident was reported, my lord, on the fateful day at 11:50 hours, my lord. 11:50 hours, my lord. And, my lord, 11:50 hours, my lord, between Rongya and Ghagrapar, my lord. And at 11:50, my lord, the train was standing on railway at Rongya station. So, my lord, it has not crossed Rongya, my lord. So, in 11:50, my lord, telephonic call has come, my lord. I'll show the, my lord, station master's diary, my lord. Station master's diary is, my lord, station master's diary it is, my lord, my lord, I'll give the station master's diary. SM diary, R4, my lord. R4 at telephonic phone, one unknown dead body at kilometers when so. Time about 15:50. So, my lord, he was informed, my lord, at 15:50, my lord. So, my lord, and my lord, as per the train register, my lord, 15:50, the train was standing at, my lord, Rangya station, my lord.
You see, there is a report. This
Police report, my lord.
yes, final report.
My lord. A final report, yes.
It stated that.
My lord, in the final report also, my lord, this is a run over case, my lord. চূড়ান্ত প্ৰতিবেদন, my lord. Second page, my lord.
Yes.
তদন্ত সাক্ষীবাদী মৃতকৰ মৃতক অসাৱধানতাৰ ফলত ৰেলৱে ৰান অভাৰ ইনচিডেণ্ট বুলি জানিব পাৰি চূড়ান্ত প্ৰতিবেদন দাখিল কৰা হয়। অসাৱধানতা প্ৰসত মানে so my lord, it's a clear case of run over, my lord. So my lord, and at that point of time, my lord, train has not even crossed Rangya station, my lord. So my lord, that train cannot, my lord, he cannot fall down from that train, my lord. And my lord, the evidence given by his son, my lord, who is not an eyewitness, my lord, he simply said that I saw him boarded the train at Guwahati station, my lord. Whether ticket was purchased, that was not also there, my lord. And my lord, how he came to know, my lord, that he has fallen down. His father was fallen down, my lord. He is not supposed to know, my lord. If he is not accompanying his father, my lord. My lord, I am harping on these 3 points, my lord. And my lord, the inquiry was conducted, my lord.
So, what are the 3 points? You briefly state again.
My lord, it's a case of run over, my lord. Body was, the train, my lord, gone over the body, my lord. Number 1, my lord. Hand were cut off. The final report also said that, my lord, অসাৱধানতা বশত incident of, my lord, both English and Assamese used, my lord. মৃতকৰ মানে this অসাৱধানতাৰ ফলত ৰেলৱে ৰান অভাৰ ইনচিডেণ্ট বুলি জানিব পৰা হ'ল। This is the report. Again, my lord, the post-mortem report, it's railway run over. And my lord, inquest report, my lord, I am relying on the inquest report, my lord, the injury, my lord. মূৰটো থেতেলা খাইছিল, হাত এখন হাতখন কাটি গৈছিল, ভৰিকেইখন সম্পূৰ্ণ ভৰিকেইখনৰ বিষয়ে কৈছে, is what is said about the legs, my lord. I'll just read out, my lord. My lord, বাওঁ হাতখন চিঙা অৱস্থাত দেখা গ'ল, সৰু দুইখন আঁঠুৰ তলত থেতেলা অৱস্থাত দেখা গ'ল, পেট নাড়ীবোৰ ওলোৱা দেখা গ'ল। So my lord, it's a case of run over, my lord. He has not fallen down then. The inquest final report also says that অসাৱধানতা বশত, due to his negligence, it's a case of run over. Number 1. Second, my lord, the incident was reported at 11:50 hours, my lord. We have produced the station master's diary, my lord. That
11:15 or 50?
50, my lord. Oh, 50, well, my lord, 15:50, my lord. 15:50 hours, my lord. On 21/9/2012, arrived Rangya station at 15:50 hours.
21/9/2012.
Yes, my lord. 15:50 hours and left Rangya station at 15:53. Reached Khagrapara at 16:04 hours. As per the station master's diary, my lord, the incident was reported at 15:50, my lord. So, my lord, if it is incident, my lord, so my lord, if it was informed over telephone 15:50, my lord, it must be, my lord, at least happened 5 minutes prior to that, my lord. But, my lord, precisely, my lord, at 15:50, the train was standing at Rangya station, even not cross Rangya station, my lord. If, my lord,
How can you establish this fact?
my lord, we have given the train diary, my lord. Train diary, my lord.
At page number?
My lord, it is, my lord, R. My lord, I'll give, my lord. My lord, station master diary, my lord, it is station master, my lord, who has reported about the incident, my lord. It is, my lord, R4, my lord. Station master's diary, my lord. R4. At serial number 7, my lord, of the station master's diaries, it was recorded that incident was reported at 1550 hours, my lord. And my lord, report of the senior divisional security commissioner, my lord.
There is no clear indication which is R1, R2. You
Um,
show from the.
My lord, I will, my lord.
Okay.
My lord. I'm so. Oh. My lord, I am flagging this by as per this, my lord, where we have reported, my lord.
You indicate there which is R1, R2, R2.
Yes, R1, R4. Is that? Register R5. R5. Probably, my lord, I'm not getting the post-mortem report. What is the post-mortem report? My lord, got it, got it. Since, well, so, yep.
So, the tribunal has observed that the burden to prove that the person is not a bona fide passenger lies with railways. So, whether you have been able to discharge it?
My lord, before going to my lord, bona fide passenger, my lord, suppose my lord, he's a passenger, my lord. For argument's sake, my lord, not admitting, my lord. Suppose he is a passenger, my lord. My lord, we have proved that, my lord, from the document, that train was standing at 1550 at Ramya station.